Get ready for the dictation. Start. The issue raised in the present appeals relates to the nature of the property, that is, whether the perpetual leasehold rights in plot number 16 Chaukhandi, Keedganj, Allahabad, Nazul plot was co-parcenary joint Hindu family property or being a part of impartible estate of the estate of Meher was closed with the incidence of self-acquired and separate property. In order to decide the controversy, we would record the facts in brief. 1. Bachchu Lonia had acquired the property by means of perpetual lease deed dated 12th September 1873 executed by the government. After the death of Bachchu Lonia, his son Ram Bharose, by means of a registered sale deed dated 12th August 1896, had transferred the perpetual lease rights to Raghubir Singh, the then Maharaja of the state of Meher. Subsequently, Brijnath Singh had succeeded to the throne Gaddi of the state of Meher. Brijnath Singh Wide registered will deed 11th February 1966 had bequeathed the palace of Meher and privy purse to Govind Singh, elder son of his first wife Surendra Kumari, and rest of the properties including the property to his second wife Rani Tej Kumari for her son after making provisions for her maintenance during her lifetime. Brijnath Singh had died on 13th October 1968. Notwithstanding this will, Govind Singh, elder son of Brijnath Singh from the first wife, as Peshwa and Karta of the joint Hindu family, had sold the property Wide registered sale deed dated 18th November 1968 to Trijugi Narayan Dubey and Surendranath Prayagwal. On 20th November 1968, Chandranath Kala and Sanku had instituted original suit number 194 of 1968 for permanent injunction against Trijugi Narayan and Surendranath, claiming right in the property by adverse possession for last 30 years. Later on, they had filed an application for amendment of the plaint as Vimal Kumar Singh, power of attorney holder of Rani Tej Kumari, had executed sale deed dated 6th June 1969 of the property in favor of Chandra Nath Kala, which application for amendment claiming title based on the sale deed was allowed by the trial court. However, this order allowing the amendment was set aside by the High Court Wide order dated 10th December 1971. Chandranath Kala had then on 7th March 1972 instituted original suit number 64 of 1972 for declaration and injunction against Trijugi Narayan and Surendranath, impleading Sanku as the third defendant, predicating his right on the sale deed dated 6th June 1969 executed in his favor by Rani Tej Kumari. Sanku admitted the claim of Chandra Nath Kala, while Trijugi Narayan and Surendranath had filed written statement inter alia stating that Brijnath Singh had no right to execute the will in favor of Rani Tej Kumari inasmuch as the property was co-parcenary property of the joint Hindu family. Further, Govind Singh, being the Karta of the family, had validly executed the sale deed dated 18th November 1968 in favor of Trijugi Narayan and Surendranath. The trial court dismissed the two suits by separate judgments, both dated 25th March 1983, deciding several issues reference to which is not required in view of the limited challenge raised by the appellants, albeit it was held that Brijnath Singh could not have by a will bequeathed the property that belonged to the joint Hindu family, and therefore the sale deed dated 6 June 1969 executed by Rani Tejkumari was void as she had no title. Further, the transfer by Govind Singh as the Karta of the joint Hindu family in favor of Trijugi Narayan and Surendranath was for benefit of the estate and absolutely legal. Suit number 194 of 1968 was dismissed on the ground that Chandranath Kala and Sanku had failed to prove acquisition of any right by adverse possession. Stop.